everyone, and welcome to this week's episode of our live webinar series, proudly brought to you by immigrationquestion.com, your trusted source for up to date immigration news, expert legal insights, and real time conversations with licensed immigration attorneys. My name is Anisha Mukherjee, and I'll be your host for today's important sessions, Crimmigration 101, Navigating Asylum with a Criminal Record. For many people fleeing danger and persecution in their home countries, asylum is a critical lifeline. But if you're also carrying the weight of your past convictions, arrest, or even just pending charges, the asylum process becomes more complicated and even more intimidating. There's a lot of confusion out there about whether a criminal record automatically blocks someone from receiving asylum in the US. The truth, it doesn't. But the details matter. And that's where criminigration, the intersection between immigration and criminal law, comes in. We are pleased to welcome back Attorney Lal as today's guest. With over 15 years of experience in immigration law, he specializes in business immigration, including H-1B, L-1, and TN visas, as well as green card categories like EB-1 through EB-5. At Gahey and Associates, he represents clients before USCIS, EORIR, DOS, and DOL. He holds a law degree from Benjamin N. Cardozo School of Law and is licensed in New York. Attorney Lal is also admitted in the U.S. District Court for the Southern District of New York and the Eastern District of New York and is an active member of AILA. Attorney Lal is glad to have you back. Welcome.
Thank you for having me and thank you for that kind introduction.
Before we dive in, a quick but important reminder: ImmigrationQuestion.com is a two in one platform that connects users with licensed immigration attorneys. We are not a law firm and are not affiliated with AILA or USCIS. All legal services are provided independently by attorneys in our network. So let's get into today's discussion. So let's start with the big one, Attorney Lal. Because it's something we hear from people all the time. I have a criminal record, so I can't apply for an asylum. Is this true? And if it's not, which types of offenses do disqualify someone from asylum?
It's a great question, but first, let me give you a background. Criminal records matter and have consequences, but depending upon what kind of application you are filing with US immigration, the consequences might differ depending upon what kind of criminal record you have. So if you are already a green card holder and you are applying for a citizenship and you have certain kind of criminal record, it might affect your application that you have a small criminal record, meaning you were arrested or convicted for a small charge within last 5 years. And then consequences would be different if you are not a green card holder, but you are applying for a green card. You're probably in a non-immigrant status and you are applying for green card. At that stage, again, the criminal record and its consequences will differ. So the consequences of criminal record will differ in each kind of application depending upon what kind of uh, criminal history was involved, how long was it ago, for what, all those factors. So there are so many factors involved in these kind of cases. But typically, uh, since today we are talking more specifically about asylum, how your criminal record affects your asylum application. So having a criminal record does not per se stops you from applying asylum. Under the law, there is a thing called mandatory bar to asylum, meaning certain kind of criminal act would mandatorily bar the U.S. immigration or the immigration code not to give you asylum, even though you maybe have a very strong case. But since you have that criminal record with you, asylum cannot be granted. Now, what is that mandatory bar? So, as per US law, there's a thing called particularly serious crime. It's a legal term. What it means is if you are convicted, again, it's a legal term, you have to be convicted, not just charged. If you are convicted of a particularly serious crime, asylum cannot be granted. Now, let's say if you were arrested for a minor misdemeanor or some kind of small charge, that's not a mandatory bar to asylum. Now, what is particularly serious crime? Essentially, there are several factors that the judge might look into it, but generally speaking, an aggravated felony offense might come under the definition of particularly serious crime. And if you were convicted, meaning you were actually convicted, not just charged, then you asylum cannot be granted to you. In addition, in many cases, we have seen the derivative applicant, meaning let's say there is a whole family applying for asylum application. There's a husband, there's a wife, and their children. Let's say the wife is the principal applicant and the husband and children are the derivative applicants. Now, and they all have a very strong asylum case. But the derivative applicant, in this case, the husband, was convicted of a serious, that we can call a serious offense on aggravated felony. In that case, even though the asylum can be granted to the wife, but it can still not be granted to the derivative to the husband because of the mandatory bar. So in such cases, or maybe the wife has a criminal record. So since the principal applicant cannot be granted asylum, the derivative applicant, in this case the husband, will not receive asylum. So in such cases, the attorney who are recently entering in this profession in the immigration field normally advise if your client has a separate claim, maybe coming out of the same individual fact, but if you see any kind of criminal history, have them file separate asylum applications so that their cases can at least be approved and then the principal applicant's criminal history will not be barred for the derivative because the other person or the derivative person already has a separate asylum application. So that just to clarify what's going on in these applications.
That's a great way to start, Attorney Lal. Now, let's say someone already has a conviction on their record. Is asylum totally off the table? Or is there other forms of protection, like under CAT, the Convention Against Torture, that still might be available for them?
So 2 points regarding this. Number one, asylum is not totally off the record. The person should get consulted with an expert who can guide, who can look into the record what exactly it is. Does it fall under the definition of particularly serious crime? Let's assume it does. So, which means asylum is off the table. Now, since the person cannot be eligible for asylum, in that case, maybe depending upon the facts of the case, the person can at least get relief under Convention Against Torture. There are certain factors that may qualify that person despite the criminal record, but then every case is differ. If someone has such kind of case, they should consult with an expert who can guide them through the process.
Thank you for that. Even if someone technically qualifies for asylum, we know that judges and asylum officers have some discretions. Can a criminal record still lead to a denial based on discretion alone? How does that work, and can anything be done to fight it?
That's a great question. That confuses a lot of people. So let's say if you have a small criminal arrest or maybe a conviction. Now, as I talked about earlier, there are mandatory bars. Mandatory bars means if someone was convicted of a particularly serious crime or an aggravated felony, then the judges or USCIS asylum officer cannot use their discretion. They have to deny their asylum application as per the law. But if someone was either charged or even convicted for a lesser offense, which does not fall under the definition of particularly serious crime, then the judges and the USCIS asylum officer may use their discretion. And I see that in my practice day to day. I have won so many asylum cases in immigration court where people had some kind of small arrest or small conviction for maybe a misdemeanor. So despite having a criminal record, their asylum cases were approved. So even if you have any kind of criminal history, specifically with minor offenses, you can still be granted asylum in the US.
All right. How about those with pending or dismissed charges? What kind of preparation should they do going into an asylum interview or court hearing? What documents should they bring, and how critical is it to have an attorney involved at this stage?
So first of all, the attorney involvement is very, very important for such cases. As a layman, as a non-legal person, you probably wouldn't understand what the charge is, what the consequences might be for the charge. People, a layman person, even an educated person, probably might not understand what conviction means, whether the person was convicted or not, if the charge was dismissed. So there are a lot of things involved in such kind of cases. So involvement makes easier this process. That's number one. And number two, what documents you need is typically when you are in immigration court, the ACC, the Assistant Chief Counsel or the Government Counsel, DHS Counsel, and the judge also would want to see what is called a disposition. Let's say you were arrested, you were not even convicted, and, when the US immigration runs your background checks, when you give your biometrics, and then your arrest record pops up in their record. Even though you are not convicted, your arrest is in your record. So the DHS counsel, the immigration judge, would want to see a certified copy of your disposition charge. So what you can do is, typically if you're in New York area, you can go to clerk's office, you can get a certified copy of your disposition charges. And you should submit, along with your supporting document of your asylum application, your disposition document. That is a must if you had any kind of criminal record, any kind of criminal arrest, even though it was very minor, you're supposed to submit your disposition document, without which the judge will not rule on your asylum case.
All right. Thank you very much, Attorney Lal. This session so far has been very insightful, and I know our audience would agree. To everyone joining us on Facebook, YouTube, and LinkedIn, thank you for being here. Whether you're a legal professional, community advocate, or someone just looking to understand this better, we're grateful to have you. And if this is your first time with us, welcome. We are immigrationquestion.com, a two-in-one platform built with lead and case management features to help simplify the immigration process. Though we are not affiliated with AILA, we are trusted by a lot of AILA attorneys who use our platform. Also, with immigrationquestion.com, you can ask your immigration questions for free in any language and get connected with a licensed attorney for legal guidance. And yes, just like many of our users, you may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com to learn more. And it gets better. We just launched our new mobile app designed to make access even easier, whether you're an attorney or a user. Now, Attorney Lal, as a seasoned immigration litigation attorney for over 15 years of experience in immigration law, what are your thoughts on the MyList system? I know you use the MyList software, the MyLegal software. How has that helped your practice?
Yeah, it's a great tool. And normally I've used so many softwares over the years. Most softwares either are good for business immigration practice or they are good for removal defense practice. I practice both. I practice business immigration as well as removal defense. So this is the only platform that I see is useful for both kind of practices combined into one. So it's a great platform.
Thank you for that. It makes us glad to know this. So before we jump into the Q&A session, Attorney Lal, there are people watching right now who are scared to even begin the asylum process because of a criminal record. What would you say to them? And what's your message to how they can move forward wisely and safely?
So if you have criminal record, please do not assume that your case cannot be approved. Please consult with a professional who can look into your criminal record, what the charge was there a conviction, can it fall under particularly serious crime definition? And in most cases in my practice, when I review those documents, they do not. I can, despite having those criminal records, I can see that I can still proceed with the asylum application. And if there are equities involved, meaning despite that small criminal conviction, if there are other equities, meaning the person is paying regular taxes, doing community service, uh, maybe other equities involved, then the case can still be granted despite that criminal issue.
Right. Thank you for that. Now we're moving into our live Q&A session. If you have a question for Attorney Lal, now is your moment. Drop your questions in the chat or call us live at 516-703-3483. Now, they're asking 5.5 months, still no decision on my EAD application through adjustment of status. Is it because I might get scheduled an interview for the green card before they approve the EAD application?
No, not necessarily. Eh, In some cases, you do get within under 5 months, but we have seen cases that we have found, some cases still are taking 8 to 9 months. So 5.5 months is nothing. You probably might have to wait for a couple of more months.
All right, thank you for that. Next question is, I was arrested back in my home country during a protest, but never convicted. Should I still mention it in my asylum application?
Yes, you should still mention in your asylum application. And if you have any kind of disposition document, you should include the supporting documents, such as police report, or when the case was dismissed, if you were given any documents, you should include that with your asylum application.
Thank you. Next question is, I pled guilty to a minor charge because my lawyer said it wouldn't affect anything. Now I'm scared it will ruin my asylum case. What can I do?
You should consult with an immigration attorney who can let you know the immigration consequences of that plea deal, number one. Number two, if the charge was dismissed, I would assume you consulted with a criminal attorney, a licensed attorney. And then if the attorney advised you that there would not be any immigration consequences, that I would assume that the attorney rightfully advised you, you should not have difficulty if the charge was for a minor offense and it was eventually dismissed.
All right, thank you. Next question. I committed a crime under pressure from traffickers. Can the judge understand that I wasn't in control?
Yes, the judges can understand the situation. There is also a thing called uh, arrest or persecution based on political opinion. But to answer your question, yes, the judge would understand if you did something under duress, and they can understand that.
All right, perfect. Thank you. Next question is, I heard ICE detains people with criminal records at check-ins. Should I go to my appointment or stay home?
Well, this question you should consult with an immigration attorney. But in general, I can tell you, yes, that's a priority for ICE to arrest people with criminal records. So if you have criminal records, ICE might detain you.
All right, thank you. Next question is, if I'm denied asylum, excuse me, because of my conviction, is there any waiver or second chance I can apply for?
So if you applied your asylum application with USCIS and USCIS does not approve your asylum application, what will happen is they will refer your case to an immigration judge. And before the immigration judge, you will get a second chance to be heard. The immigration judge will hear your asylum application, will hear your case all over again, and then again decided whether to approve or deny.
All right, perfect. Thank you. Next question is, my ex-partner forced me to do things I regret. I got arrested once because of it. Will that ruin my asylum claim as a domestic violence survivor?
It would depend what exactly you did, whether you were convicted or not. So in this case, I would recommend you should speak with an immigration attorney who can guide you regarding your case and let you know whether your case uh, would eventually go through or not. So you should definitely consult with an immigration attorney.
Thank you. Next question is, I heard that once you have a criminal record, you can never get asylum. Is that true?
It's not exactly true, as I mentioned before. Despite having a criminal record, your case can still be granted. But it all depends what kind of uh, criminal issues involved. If you are convicted of what is called particularly serious crime or an aggravated felony, then yes, the asylum will be denied. But if you are arrested or convicted for a lesser crime, maybe for a misdemeanor, and there are greater equities in your case, meaning there are certain positivities in your case, then asylum can still be approved.
Thank you. Next question is, and that is the end of our questions. That was an incredibly insightful session. Thank you again for joining us, and a huge thank you to Attorney Lal for the practical strategies and insights you've brought to today's discussions. We hope this conversation gave you clarity on navigating asylum with a criminal record. Don't forget, at immigrationquestion.com, you can ask your immigration questions for free and get in touch with a licensed attorney who understands your case. You may also be eligible for a free confidential initial consultation. So head over to immigrationquestion.com and sign up today. And if you want to revisit this session and share it with a colleague, you can catch the replay on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us again on Friday for another enlightening conversation with another immigration attorney. Trust me, you won't want to miss it. Once again, thank you so much, Attorney Lal, as always. It's great
Thank you
to
for
have
having
you.
me. Thank you.